Navigating estate planning can be challenging due to the complexity of legal terms and the variety of documents involved. Understanding the difference between a power of attorney and a power of appointment is a common source of confusion. Both are essential for a solid estate plan, but serve very different roles. A power of attorney allows someone to act on your behalf during your lifetime, while a power of appointment determines who receives your property after your death. Understanding the distinction is crucial, and in this video I'll explain what a power of appointment is, why it's important, and how it helps in transferring wealth effectively. Let's dive in. Before we jump into power of appointment, let's quickly refresh what a power of attorney is. Think of it as an authorization that lets someone, known as your agent or attorney in fact, handle legal or financial matters for you. This could be for healthcare decisions, managing property, or legal representation. The agent is a fiduciary and should always act in your best interests and avoid self-dealing. Setting up a power of attorney is straightforward and does not require state recording. You can choose one or more agents who can act together or separately depending on your needs, and you can replace or revoke their power anytime as long as you are legally competent. There are several types of power of attorney. A general power of attorney grants broad powers to the agent to handle a wide range of financial and legal matters. These can include managing bank accounts, signing checks, buying or selling property, and making investment decisions. A general power of attorney stops when the principal becomes incapacitated or can't make decisions for themselves. In other words, it's not good for end-of-life planning. A general durable power of attorney stays in effect even if the principal becomes incapacitated. It's crucial for ensuring that someone you trust can manage your affairs if you are unable to do so. General power should typically be reserved for a spouse. A limited power of attorney restricts the agent to specific tasks or time periods. For example, you might grant a limited power of attorney to allow someone sell a car for you while you are out of the country. Finally, there is also a springing power of attorney, which only takes effect under specific conditions, such as if the principal becomes incapacitated. For estate planning, a general durable power of attorney is usually the best choice because it remains in effect through incapacitation and ends only at death. Now, let's talk about power of appointment, a useful tool that adds flexibility to your estate plan and potentially significantly reducing taxes. While a power of attorney lets someone control your affairs, a power of appointment lets someone decide who will receive your property, typically within a trust or will. The person who grants the power is known as the donor, and the person who receives the power is called the power holder. For example, you could grant your child the authority to decide which of your grandchildren will inherit your property, perhaps 10 years after your passing. There are two types of powers of appointment. A general power of appointment allows the power holder to assign the property to anyone they choose, including themselves, their estate, or their creditors. A limited or special power of appointment, as the name implies, restricts the power holder's choices to a specific group of people or entities, excluding themselves, their creditors, their estate, and the creditors of their estate. Usually, the limited power of appointment requires the power holder to assign the property to specifically named beneficiaries, such as children or grandchildren. A good example of a limited power of appointment is granting my son the authority to distribute certain property among his children, either outright or through a will, in equal or unequal shares. In other words, my grandchildren should ultimately receive the assets rather than my son, his wife, his creditors, or his friends. Another common example of a limited power of appointment is a power that is limited to an ascertainable standard, also called the HAMS standard. This standard permits the distribution of funds to the recipient's health, education, maintenance, or support. By using a HAMS standard, the donor enables the power holder to allocate assets to themselves without establishing a general power of appointment. For example, you can grant your spouse the power to allocate 1 million from your bank account to herself and her mother, but solely for health-related expenses. In this scenario, while your spouse can direct assets to herself, she is restricted to using them exclusively for healthcare purposes. Another feature that can be added to a power of appointment is whether it is designated as a testamentary power of appointment or a lifetime power of appointment. A testamentary power of appointment can only be exercised through the power holder's will or trust and becomes effective upon their death. It specifies how the property under the power should be distributed at that time. Unlike a testamentary power of appointment, a lifetime power of appointment can be exercised during the power holder's lifetime, allowing the distribution of assets at any point before their death. For instance, the power holder can claim a gift for themselves immediately or assign an appointee at any point during their lifetime. In addition to standalone powers of appointment, there is also the power of appointment trust. This irrevocable trust can be established either during one's lifetime or upon death. It grants a beneficiary a power of appointment over trust assets, which can be general or limited, based on the trust terms. A power of appointment trust is often utilized in estate planning to leverage the unlimited estate tax marital deduction. To qualify for this deduction, it's crucial to grant the surviving spouse a general power of appointment over the trust assets. Additionally, this type of trust can help avoid the generation-skipping transfer tax, which I will discuss in my future videos. Including a power of appointment in your estate plan provides flexibility and control over asset distribution. It is especially useful in changing circumstances situations. For example, if you're considering leaving $100,000 to each of your grandchildren, using a power of appointment can be more advantageous than an outright gift. This approach allows you to designate a power holder who can decide later which grandchild receives what and how much. With an outright gift through a will, you cannot anticipate issues like drug or substance abuse, gambling addiction, or financial irresponsibility. A power of appointment enables the power holder to address any unforeseen issues and make adjustments years later. From a tax perspective, a general power of appointment can help your heirs save significantly on capital gains taxes. By granting a general power of appointment to someone over an appreciating asset, you can transfer the asset from your estate to the power holder's estate. When the power holder passes away, the heir, often grandchildren, will receive a step up in basis, meaning the value of the appreciating asset is adjusted for tax purposes at the time of inheritance. If the asset is sold later, this step up can substantially reduce capital gains taxes. In a trust, a power of appointment can offer flexibility in distributing the trust assets, ensuring they are allocated in the most beneficial manner for the beneficiaries. Despite their advantages, powers of appointment should be used carefully due to potential significant implications for estate taxes. When a power holder holds a general power of appointment, the assets under this power are included in their estate for federal estate tax purposes. This means the value of these assets gets added to the power holder's estate, potentially raising their estate tax liability, especially if their estate is large. Assets under a limited power of appointment are not included in the power holder's gross estate. However, the power holder has the ability to alter the donor's beneficiaries, which could potentially exclude certain individuals from inheriting. For example, if a donor intends to leave a specific asset to a grandchild only if he or she graduates from college, a contrary power holder could still allocate the asset even if the grandchild never attends college, which would go against the donor's original intent. When incorporating a power of appointment into your estate plan, ensure that the terms of the power of appointment are clearly defined in your estate planning documents to prevent any confusion or disputes among beneficiaries. Choose your power holder with care. This person will have substantial control over how your assets are distributed, so it's important to select someone who is trustworthy, capable of making sound decisions, and aligned with your wishes. Consult with an estate planning attorney to ensure the power of appointment is properly structured and fits with your overall estate planning objectives. If you need recommendations, do not hesitate to reach out to us. In conclusion, the power of appointment is a powerful tool for flexible and effective asset distribution in estate planning. Understanding the differences between it and the power of attorney helps you make informed decisions for your beneficiaries and potentially minimize taxes. Also, always seek professional advice to tailor your estate plan to your specific needs. That's it for today. If you liked the video, please give me a thumbs up and subscribe to my channel. And if you'd like to learn more about how we help our clients in protecting their wealth and maximizing the lasting impact of their legacy, be sure to visit us at www.lestna.com. Thanks for watching.